Earlier this afternoon, the defense attorneys have withdrawn their representation of Mr. Allen. Mr. Baldwin made an oral motion to withdraw. I granted that oral motion to withdraw, and Mr. Rosie will be submitting a written motion to withdraw, I'm assuming within the next couple of days.
Rosie and Baldwin both say they want to stay on the case, and they're now fighting back. Yesterday and today, Rosie and Baldwin filed new court filings, claiming the judge coerced them into stepping down. The attorneys say last week in her chambers, Judge Gall falsely accused them of gross negligence. They claim the judge ambushed them and said if they did not withdraw from the case, she would publicly shame them in court and then disqualify them from continuing to represent Richard Allen. Rosie and Baldwin say their decision to step down was involuntary, and they are asking to remain on the case. But in a new twist today, the judge wiped out all public record of those requests. Judge Gall said since the attorneys withdrew, she has ordered their recent court filings to be stricken from the record, and she even ordered the clerk to also remove them from the electronic case file. That is a surprising and aggressive move that could prompt appeals by the defendant or the defense attorneys. Now, despite all that, just a few hours ago, Judge Gall announced the new defense team. William Labrado, Allen County's chief public defender, and Robert Scremin, another Fort Wayne attorney.
Then just this morning, a different group of attorneys filed a petition with the Indiana Supreme Court. They want the justices to rule the judge acted inappropriately by removing court records from the file. They want all the recent court filings reinstated.
Yesterday, Judge Gall refused to reinstate Andrew Baldwin and Bradley Rosie as Allen's attorneys. I talked to longtime defense attorney Ben Jaffe this afternoon. He says the state's high court has great leeway in how they rule on this petition.
I think they could reinstate these attorneys as the attorneys of record, as the appropriate attorneys. I think they could acknowledge their continued representation as pro bono counsel if they want. I think there's quite a bit they could do there. And the Supreme Court's well aware this is getting a lot of press. This is getting a lot of attention, national attention. So I do think they'll be careful and thoughtful in the way they look at this.
Richard Allen has made it clear that he wants Baldwin and Rosie to continue as his counsel. But Judge Gall says the original attorneys engaged in gross negligence. Coming up at 6, while legal experts say this gross negligence has not really been defined, and it may not be enough to kick them off the case anyways.
Thank you. You may be seated.
We are on the record in State of Indiana versus Richard Allen. I'll show that the state is here by Mr. McClelland, Mr. Luttrell, defense is here by Mr. Labrado, Mr. Scremin, and I note yesterday, late, the written appearance by Mr. Rosie and Mr. Baldwin. Mr. Labrado, earlier this morning, you filed a motion to continue the jury trial? That's correct, Your Honor. Go ahead, sir. I explained that to Mr. Allen, okay? And what is the state's position? Judge, the state has no objection as long as the time is chargeable to the defendant. Okay. And, Your Honor, that's in our motion that we would accept all the CR4 time. Yeah, I show in paragraph 4 the state doesn't object as long as CR4 is charged to the defendant. Okay, so then we have the appearances by Mr. Rosie and Mr. Baldwin. Gentlemen? Judge, Mr. Allen has asked us to represent him, and we entered our appearance to represent him. Okay, well, as we had our hearing on the 19th, prior to that hearing, we had some discussions. Counsel, you withdrew. You chose to withdraw from the case, rather than be removed for gross negligence. What's changed in the 12 days? Well, Judge, I think I've made it abundantly clear in my pleadings with the court that the conduct of the tribunal in chambers a week and a half ago left us with no choice but to withdraw because we were going to put ourselves in a direct conflict with our client by sitting in the courtroom and accepting, what was a lashing, essentially, from Your Honor. And so that was a strategic move so as to protect our clients' rights, and I think I've made that abundantly clear. I don't know how that couldn't be clear at this point. Beyond that, us transitioning from contracted public defenders to private counsel puts us in an entirely different situation with our client, which is the Sixth Amendment, his Sixth Amendment right to have representation. And to the extent that the court is trying to intervene into that right without some due process, it's my client's contention that that's just not appropriate, and he has his right to have counsel of choice. So I don't really know that there's much else to say. I think in the normal course of business, I'm a private practitioner. I was once a public defender. In the normal course of business, and in every other case I've been involved with, when there's a public defender assigned to a case, such as Mr. Scremin and Mr. Librato, excuse me if I messed your name up, but in every other case, when private counsel enters their appearance, the public defender taps out and basically private counsel gets up and running, and I don't see why this case should be any different. Well, again, you haven't answered my question that nothing has changed in the past 12 days since I found gross negligence on the part of the defense in representing Mr. Allen. Well, the answer to the question is that we didn't act grossly negligent, and the court has an opinion that's different than our opinion. And, at this point, without some due process and some findings with a notice, an opportunity to be heard, that we're just on a different page about how we acted and what our circumstances are. So that's the answer to the question. Does the state have any opinions or wish to weigh in? Judge, I guess I'm just at a loss at this point. We've struggled up to this point, Judge. And again, I was there in chambers in the meeting. I agree with the statements made by the court about the defense being grossly negligent. Again, this started back at our first hearing, back, I believe, in November, with the actions outlined by the court about defense's statement in chambers, and then a kind of direct 180 from that statement once they left chambers. And then there was a leak from the defense in December that wasn't made aware to the state or to the court until the state found out. Then we have the various motions that were filed with not only negligent statements, Judge, but I think outright lies. And I think that's been proven in court and hearings that we've had. We then have the Franks motion that was filed, Judge. What you have to outline in a Franks motion is very clear, and defense counsel spent over 100 pages outlining their theory of the case instead of argument for the Franks. And again, I think everything they've done, including the most recent leak, is just an effort by them to push this case out into the public and try this case in the public eye and not in this court. The state's concern is that Mr. Allen has a fair trial. That is the state's concern, but that goes both ways. We deserve to have a fair trial too, Judge. That right goes both ways. And I just don't think the actions by the defense can be attributable to anything else but gross negligence, Judge. So that's the state's opinion. Mr. Allen, I understand you wish to have Mr. Baldwin and Mr. Rosie represent you in this matter. I have grave concerns, Mr. Allen, about their representation of you. The previous findings by this court of their gross negligence. Mr. Allen, you are entitled to adequate representation in your case. You are entitled to a vigorous defense in your case. And this is difficult, Mr. Allen, because I know what you want. You've indicated that through your attorneys. But I cannot and will not allow these attorneys to represent you with the concerns that I've had, with the gross negligence that I have found. They withdrew rather than be found grossly negligent and be removed. I can't do it, sir. I just can't. Judge, let me finish. I cannot allow that. I have appointed able counsel to represent you. Mr. Scremin is here. Mr. Librato is here. They have an investigator here as well. I will grant their motion to continue your trial. And I'm sorry that this is happening to you, Mr. Allen. Mr. Librato, Mr. Scremin, I know that you have not talked with the state. I know that you have not yet received discovery. There is no way that you can tell me when you will be ready for the trial. I have asked former counsel to cooperate. I have asked former counsel to provide discovery to you. It is my understanding that Mr. McClellan, you've indicated that has not been provided to you. Correct, Your Honor. Gentlemen, when can I expect that you would return the discovery to the state of Indiana? By the end of the week, perhaps today. That would be great. And if you could get it today, that would be wonderful. Then that can be provided to successor counsel. You are not required to cooperate with successor counsel. I hope that you would, in Mr. Allen's best interest, but that's entirely up to you. If you could have the discovery to the state by the end of this week, that would be great. I know that I'd previously entered an order that discovery was to be complete by November 1st. Obviously, that's not going to happen. Do you want to pick a trial date, Mr. Librato, Mr. Scremin? Yes, Your Honor. Briefly speaking with the state, tentatively, we would like a trial date in November, but not knowing what exactly we're going to be getting, I can't tell the court with any certainty that we would be ready in November. We will do everything in our power to be ready by then. It's my understanding that it's a massive amount of discovery. It is. Karen, I know you brought the calendar in. Could we get a date in November? Okay, I'm looking at November 2024. There's an election day, there's a Veterans Day, and then Thanksgiving. If October or December would be October, that's fine, Judge. The state, whatever is fine with the court is fine with the state, Judge. Mr. Scremin, Mr. Librato, October would be fine, Your Honor, for a start. Then why don't we look at October 14th as marked off? What is that? Columbus Day, Your Honor. Columbus Day? Thank you, Karen. You may mark that off. So we'll look at October 15th through the 31st. Fine, Judge. And we, again, would pick the jury in Fort Wayne and bring them here to Carroll County for the trial. There's a pending motion to suppress. There is the Franks that is not yet. I haven't finished even reading it or going through all of the hours of interviews that were provided on a flash drive. So you'll need a hearing date for that. Once you get the discovery and once you've had the opportunity to review the pleadings, you can either adopt those pleadings or make your own. It's up to you. Anything else from the state? Judge, we want to create a record to be clear on what you're doing. You are disqualifying Brad and me. Is that correct? Correct. We would like to be heard through my attorney, David Hennessy. Sure. Good morning, Your Honor. I do have a limited appearance on record which hasn't been removed or disqualified. The court has my preliminary memorandum about disqualification when Mr. Rosie and Mr. Baldwin were appointed counsel. This is yet different. The law that I gave the court is even more certain. The court appears to be saying that it's protecting Mr. Allen, but the court's finding of gross negligence was summary, without notice, without opportunity to be heard. Had you given Mr. Rosie and Mr. Baldwin notice of your intentions on October 19th when they were formed, which seems to be like a week earlier, then they could have been prepared. I can tell you this on behalf of both of these gentlemen. You would have the Indiana Public Defender Council come testify. You would have competent attorneys from across the state come testify. You would have defense counsel that have been declared experts in criminal defense. Mr. Baldwin's one of a handful of lawyers in the state that is certified in criminal defense. So your summary ruling violates the Constitution, and your summary ruling is unfair to everyone, especially Mr. Allen, because he was never able to make a record. Your finding of gross negligence, what you cited to them in chambers, which has never been put on the record, is not gross negligence. It's a zealous representation, maybe too zealous for the court's favor, but it was good lawyering. The memorandum on the Franks issue is a work of art. It's legal writing at its best. This has nothing to do with the Franks issue, sir. No, but nothing to do with that, so please stay. No, it has to do with your finding of gross negligence, and what I'm citing to the court are the activities. I never mentioned the Franks. I'm sorry? Never mentioned the Franks hearing, never mentioned the motions, sir. Okay, you mentioned the transport orders. Unfortunately, the public and I was not allowed in representing Mr. Baldwin, and unfortunately, the public and I aren't privy to the recording of the session outside the presence of Mr. Allen. He has a right to be present at every critical stage of the proceedings. When the court coerces a withdrawal or quitting, that's a critical stage of the proceedings. He wasn't present. And I'd be happy to address each and every point that you think constitutes gross negligence. I've practiced criminal defense for 40 years. I understand and know in detail what these two lawyers have done on behalf of Mr. Allen has been nothing but zealous representation. So thank you. I have no expectation you'll change your mind for allowing us to make a more complete record about your finding of gross negligence in disregard for Mr. Allen and unfairness to Mr. Baldwin and unfairness to Mr. Rosie. Thank you, Mr. Hennessy. Thank you, Judge. Anything else from the state? No, Your Honor. Mr. Scremin? No, Your Honor. Thank you. Mr. Librato? No, ma'am. All right. Thank you very much. We've set a trial. We are in recess.
About the judge's ruling. Baldwin, can you provide any comment?
Journalism. It's time for you guys to start being journalists.
Just to add some of my concluding thoughts here, we can sit here and talk about all the violations of Allen's constitutional rights, such as his right to choice of counsel that is guaranteed under the Sixth Amendment of the U.S. Constitution, as well as his rights to be present at all critical points of the proceedings and rights to due process, have been ruthlessly and inhumanely violated by Carroll County and Judge Fran Gall. But I will let the attorneys speak on all that and prove that to the Indiana Supreme Court. What really sticks out to me, though, as a citizen observer, is the lack of foundational basis for the judge's rulings and her consistent use of ad hominem attacks that the state then backs her up in sort of this moral bullying type capacity. When Judge Fran Gall made this finding of gross negligence, she does not cite either the state or U.S. constitutions. She doesn't provide any relevant case law or even professional rules of conduct. Her assertion is subjective, unsupported, and unlawful. And she's using this assertion, this opinion, this feeling that the defense attorneys give her without any sort of foundation of the law or findings of fact. She's using that opinion to delay Richard Allen's trial by another year. She's sending him back to prison for another year because she doesn't like the attorneys. And she has hijacked his representation by appointing counsel that she is familiar with. Thankfully, though, this has been brought to the attention of the Indiana Supreme Court, and they have agreed to hear the matter. The justices have allowed Fran Gall until November 16th to submit her brief, or basically her side of the story, to the court, and I assume they will either issue a decision or hear oral arguments at that time. Interestingly, the state attorney general's office has declined to represent both Judge Gall and Carroll County. The Attorney General's office typically represents government officials in appeals and legal matters. So it is noteworthy that the Attorney General's office said, nope, we're not going to represent the government in this matter. So Judge Gall actually had to hire her own attorney, and he's from Marion County. His name is Matthew Gutwine. And upon a couple Google searches, you may or may not find his name associated with $1 billion Medicaid fraud, allegedly. But that may shine some light on the company that Judge Gall keeps and how her conduct may be similarly unethical, unlawful, and egregious. But that's not for me to decide. I'm just thankful that this matter has been accepted by the Supreme Court of Indiana, and I hope that the Supreme Court justices understand that Hoosiers, Americans, and citizens of the world are watching, and our faith in Indiana's criminal justice system, if any modicum still exists, lies in the balance of their ruling and their protection of the citizen, Richard Allen, in this matter. And I hope that they reinstate his representation, as is his right, and remove, sanction, and investigate Judge Fran Gall and the entirety of Carroll County law enforcement and prosecution's office.
I've heard from elected mayors, both Republican and Democrat, from other elected officials from around the state, local community groups, citizens, lawyers, judges, prosecutors, and people I've never even met have shown tremendous support. Now is our time. Now is our time, and we must acknowledge our system is not working. But I want to make something very, very clear to everyone. This is no one's fault. This is no one's fault. No one agency, no one judge, no one prosecutor, no one police agency, no one mayor, no one city county council, and that list could go on and on. The position that we have found ourselves in has happened over time. But it's sure been fast-tracked over the course of the last couple of years. Our time is now to get really uncomfortable with each other, to take full responsibility for all of our citizens and for all of our actions, not just one part of the system, but everybody involved in the system. We must evaluate what we do, why we do it, and then be transparent with very objective results. We must establish criteria for evaluation and then unapologetically accept it. We must not live within a shadow of accountability. Rather, we must embrace a structure where we encourage and publicly discuss accountability, just like you expect from us. Judges and prosecutors alike should be perpetually accountable through objective evaluation, or at least an evaluation period, where they must explain their decision-making processes, especially for violent felons. Especially for violent felons. Prosecutors and judges, even unelected ones, have absolute immunity, which means they cannot be held personally liable for their actions. We can and should do better.